Welcome back to Subject to Cross. We are your hosts, Pete Kratza and Caroline Donato. I'm going to start this episode, which is about probation reform, specifically Act 44 of 2023. And this was brought to our attention by a friend and I didn't realize a listener of the show who works in the Chester County Probation Department. I'm not going to name him. I didn't get permission to do that. But thank you.
You got pretty narrow there.
But thank you very much, Chris. Can I say Chris? For bringing this to our attention.
Mike.
Yeah, right. In any event, we also got, I don't know if our friend sent this to us or if we got this on our own, but this is a summary of the Probation Reform Act of 2023, which I got most of this information from. And probation isn't necessarily a sexy topic, right? Like when I thought about an episode about probation, I'm like, oh man, how am I going to keep this interesting? But it actually is really interesting because I think that the perception of criminal defense lawyers is that, you know, we walk people through, whether it's a trial or a guilty plea or a guilty verdict, and then they're supervised and that's the end of it. Well, no, there's room for more advocacy on the part of defense lawyers. And I think it's also interesting because to the uninitiated, and I think a lot of our listeners are the uninitiated, they have no concept of what probation is. In fact, I get asked that question all the time by clients. You know, what's probation going to look like? And I'm like, well, you know, I haven't done this for 30 years. I'm like, well, you know, it's like you should just know what probation is going to look like. But I think it's helpful to take a step back and explain it.
Well, okay, so you're going to make probation sexy.
Yeah, that's what I'm going to make probation sexy again. Okay, so the highlights of this act, which I think it's a Shapiro, Governor Shapiro backed legislation. It is somewhat progressive, right? Is that the language I would use?
It's actually, it is and it's not. It's a little reflective of federal court.
Yeah, and I think it also is reflective of reality, which is there are too many people being micromanaged on supervision, on probation. I'm pretty sure they've done studies to establish that their resources should really be directed toward the charges, whether they're people on parole or probation. I'll talk about the difference real quick. That they should be focused on those people. I almost said folks. I hate the word folks.
Why are you pointing at me as you
tell
me this?
Yeah, I can't stand that. I would never use that word.
Could you actually, when you talk about the difference between parole and probation, I think it would also be, this is all different types of supervision.
Right.
It's post-sentence supervision, but maybe contrasted to pretrial supervision. I think people might not know they're not interchangeable terms, the different terms.
So before somebody is convicted, they are on bail. And if they are on reporting bail, they have to report to a bail authority. It's called different things in different counties. Here it was always called the bail agency. Now it's called pretrial services. Pretrial services in Chester County, at least, is an arm of the probation department. It's not nearly as invasive as, lording over you. You know, you'll have certain conditions while you're on bail. If it's a domestic case, you're not allowed to have any contact with the victim. If it's a case that involves an allegation of drug abuse or alcohol abuse, they may mandate a drug and alcohol assessment and treatment. And you report maybe once a month normally to the pretrial services that you're in compliance, that you're attending court.
And usually that's just a phone call.
Right. The primary function of pre-adjudication supervision is just supposed to be to make sure that you appear for court and that you're not a menace to society, right?
And
my words, not theirs.
And those terms are all interchangeable when it comes to pretrial.
Right.
Pre-adjudication supervision is bail. Bail is pretrial supervision.
And then if in the event that someone is sentenced, whether after a trial or a guilty plea, they are sentenced either to jail time and they are paroled ultimately. So, for instance, let's say they go to jail for 6 months and the sentence that they receive is 6 months to 23 months. they're paroled at or around the 6 months, and then they are on parole supervision for 17 months. That's the balance of their sentence, the 6 to 23-month sentence. In effect, well, and then probation is somebody goes in front of a judge and the judge sentences them to 2 years probation. So now that person is considered a probationer. The person who has served versus the person who has served the 6 months, they're a parolee. The way that those people are supervised at the county level, which is where I'm speaking of right now, it's not really much of a difference. It's not like they demarcate parolees versus probationers. And all the probation department is doing is ensuring that they're not a danger to society or themselves, and that they're complying with their conditions and paying their money. And it's as simple as you report as directed and you verify that you're doing all those things. So, and that's what I'm talking. I should stress, we're talking about county supervision at this point. State supervision, and I'm sure we talked about it in one of our episodes, if you get a sentence of greater than 1 year of in prison to greater than 2 years of prison, then that's a state sentence. And if you were paroled, for instance, let's say you got 3 years to 6 years, you would be on parole for those 3 years. And the rub with state sentences are you don't necessarily get parole to your minimum anyway. But the point is that when you get out of state prison, you're on state parole, and those are separate probation officers, state probation officers, state parole officers who would supervise you. So I'm talking about county supervision right now. Did that answer your question?
Did I have a question?
Yeah, you wanted the difference between probation and parole. Let me get to the highlights of this act. The cool things about this act are that there are now mandatory probation review conferences. And by the way, the effective date of this, whether to sentences or resentences, is June 11th of 2024. So this all kicks in June 11th of 2024.
Also, just to add to the appeal of this topic was a very hot topic when it was being litigated related to Meek Mill.
Free Meek.
Free Meek.
Yeah.
And Meek Mill was a part of this bill.
Yes, he was. And he was represented by our good friend Brian McMonigal, and Meek Mill became a symbol. And now, who's the other guy? Rubin, right? The Fanatics guy. He used to be an owner of the Sixers. He was at this.
Oh, Michael Rubin?
Yeah. So he was also an advocate for Meek Mill, because Meek Mill was basically on the rat wheel of probation violations in Philadelphia, and he did like wheelies on a bike, and she sent him back to jail. She just wouldn't let him get off of supervision, the judge. That was the argument.
And what Pete means when he's saying get off of supervision, when a person is on probation and there's an allegation of a violation of probation, ultimately the person can be resentenced for that violation, which could be to elongate the probation, which could be to put the person in prison for a certain amount of time, or for the duration of the rest of the sentence of probation. It can have so many various forms, but because of the ability to violate someone on probation and to make their probation go on endlessly, if someone isn't given the tools to successfully complete probation, they get stuck in the system of violations, reoffending, resentencing, resentencing, violation, etc. And that's one of the problems. That's the rat wheel.
The rat wheel. Okay, so we were talking about mandatory probation review conferences. This isn't even the best part of this legislation, but this is cool. What it does is it mandates that the court and the probation department schedule these review conferences and consider reducing, or I should say early termination of probation. I think it's basically rule of thumb at about 50% of the probation. If you're on probation for 2 years, at a year, they'll have this review conference, and if the person's doing well, it seems to me there's a presumption that probation should be terminated. Here's the other one. Presumption against confinement. That's awesome.
So cool.
So in minor technical violations, and there are all kinds of exceptions that remove this presumption against confinement, but the presumption, the marching orders for the judge are confinement, putting them back in jail, or putting them in jail off of a probation sentence. This isn't parole, this is probation. that the presumption is that they shouldn't put them in jail for technical violations. What's a technical violation? Technical violation is not reporting to a probation officer. A technical violation might be giving a hot urine, which is, you fail a drug test. So that's cool. And this one was my favorite: individualized conditions of probation. You know me. One of the things that I always rail against is a cookie cutter approach to cases, defining people by the crimes that they're being sentenced for. And I see this most in sex offense cases, frankly, that they're labeled. Everybody seems to think that sex offenders are going to be reoffending. They're labeled as recidivists, even though a lot of the research indicates that that's not the case. And nobody really cares about people that are on supervision, especially, for crimes that are repugnant.
Sex offenses involving children, you mean?
Until it's them or a family member that's on the rat wheel. So individualized conditions of probation, to me, and I make this, and this is the other reason this really is important to me. One of the reasons that I hate mandatory sentences is that it takes away from a judge the ability to assess an individual, to assess the individual's act of offending, all the mitigation that we bring forth about that person.
You're talking about mandatory minimums.
Yeah, right. So individualized, I am all about individualized sentences, and that's consistent with this. Individualized conditions of probation. You're sentencing an individual, judge. You're not, just a scorekeeper. You're not looking at, this is the crime and this is the offense gravity score, and I don't care about your guy. This is what my box tells me to do. And I think that judges can fall into that trap. And what this is saying is no.
Use your discretion.
Pay attention.
And also,
do you think that'll work if I say to a judge, pay attention?
Only if you point at them.
Okay.
And also, it kind of dovetails back into previous topic we've addressed with 3553A under Title 18 of the United States Code. When you're talking about the individualized person, what sentence is sufficient but not greater than necessary to serve the purposes of sentencing, one of which is rehabilitation. So with probation, to give the court some discretion to individualize that supervision, it's the same thing. What does this person need? How can this person succeed? Because a lot of this bill is to make sure that people get off the rat wheel and can successfully transition back into society.
And incarceration as a last resort. It would be nice if our legislature and governor looked at the standards of sentencing themselves. Remember, I think in that episode, we pointed out the difference between the federal standard, which is the least restrictive means to,
sufficient but not greater than necessary.
They don't have that in Pennsylvania.
Versus it was something like most important is retribution in Pennsylvania.
Protection of society, I think, something like that. End probation for indigent probationers, notwithstanding fines and costs. We kind of do that here already. I credit Chester County. They just move them to like a collections unit or something like that.
We're lucky. Chester County's lucky. It has a really good probation department.
You're just saying that because they listen to more podcasts.
I'm not. They know. I'm not going to shout people out, but if they're listening, they know who I'm talking about.
I used to play on their softball team at one point. I'm a really good softball player. At least I was. But no, I think it's a testament to the probation department that a lot of people work there so long. They like working there. So thank you for pointing this out. I do have one criticism.
Wait, you're done? There's so much more to say.
Oh, well, I'm going to let you talk, but I'm just about done unless you want to get me to talk more. I do have just a nitpicky thing.
Okay.
So this probation reform summary was sent to us was prepared by, you ready for this? Mm-hmm. The CCAPPOAP.
What?
Exactly. So I had to look that up. That is the County Chief Probation and Parole Officers Association of Pennsylvania.
I'm sure there's a more efficient acronym.
That has to be the worst acronym I've ever heard in my entire life. I mean, I guess you pronounce it.
So many letters.
This is how I phonetically did it. APOAP. So, Chris, maybe one of the things you can suggest is shortening that acronym. I mean, we have PACDL, the Pennsylvania Association of Criminal Defense Lawyers. It always has been, my goodness.
That's a loud
I think the
one.
police are coming for us. It always has been and I knew this early on with your father, one of the things that's like nails on a chalkboard
Pactyl?
for him, pactyl. And people call it pactyl.
It's like a pterodactyl.
Yeah, I always think of like a dinosaur. But PACDL. But no, the OAP, that needs to be worked on.
That's your criticism.
That's my criticism. Maybe I'm nitpicking.
So our friend wanted to know our take on this.
Oh, yeah,
There's
that's true. I guess we need to do that. I said I like everything.
I like a lot of the things. I like that if the court wants to increase conditions, it has to make a finding by clear and convincing evidence that the person presents an identifiable threat to public safety. That's a higher standard of proof. I like that. I think that really puts the onus on the court to make some findings of fact to restrict someone's liberty in a violation. I'd be curious to know how probation feels about this, though, because even though we see
Maybe
it as...
Chris will agree to come on and talk about it.
Yeah, the way we see it is, okay, this is really great for due process. This is really great to shorten probation tails. This is really great to get people off the hamster wheel or the rat wheel. As
Is
you
it a
identify,
hamster
it's a
wheel?
hamster wheel, but you said rat wheel, and that's catchy.
Yeah, all right.
But it's a lot of work, it seems, for the probation office.
It's designed, one of the stated purposes is to lighten their caseload so that they can then concentrate on those higher risk individuals.
I guess I think they're going to have to work in tandem with the DA's office in negotiating these pleas, because if they have to create these reports, and this kind of looks like a pre-sentence investigation report in federal court, and then both parties can raise objections. That's part of the process here. After a certain period of time, whether it's a year for misdemeanor or 50% for misdemeanors, and 4 years for felonies, then the probation office has to prepare a report about the status of the probation and I suppose recommendations, and then the DA's office can lodge objections, defense can lodge objections. If there's no objections, then the court signs an order.
Just to clarify, for misdemeanors, it's 2 years of probation or 50% of the sentence, whichever is sooner.
Right.
For felonies, it's 4 years or 50%, whichever is sooner. Okay.
Thank you. But it's a lot of work up front for the probation officers. Now, will it pay off long term to really help them identify and focus on, those cases that need more attention? I hope so. But I would be curious how they're feeling about what their workload's going to look like and how that's going to translate to pleas.
Well, and I also think that there's hopefully the courts and the probation department, and probation officers are generally more practical than lawyers, which are prosecutors and judges. But it seems to me that there should be a way to streamline this. And I say that just because probation officers aren't lawyers. But the point is that I think that there can be a mechanism where you're on probation, Caroline, for 3 years, and at a year
What
and
did
a
I
half,
do?
welfare fraud. And when you're on probation for welfare fraud for 3 years, at a year and a half, they say to you, we can have this review hearing, but we're willing to terminate your probation. Is that okay with you, Caroline? And you say yes, and that's the
But
hearing.
they still have to submit the report. The DA's office
Right, but
has
it
an
could be
opportunity
streamlined.
to object.
Yeah.
But that goes into another point. As counsel, usually our representation of a client ends when they're sentenced. Now, because of this reform and this review period, do we stay on? Is that a separate?
I think they got to hire us all over again if they want to.
Okay,
But I don't know.
Future clients, you're on notice. Pete Kratz says.
Yeah, I'm going to put it in my fee letter. I did, and I'm not done. One of the things that I do find a little bit odd about this, when they talk about revocations and presumptions against total confinement, they have different burdens of proof in here. So there's a presumption against total confinement for technical violations.
Can you explain to the listeners what a presumption means?
So presumption means, you put me on the spot, that basically you got to work against that. The default is the default
assumed.
position is no confinement. If you want to put them in jail, you got to overcome the default the presumption that they don't belong in jail.
I taught Dad's class last night at Villanova, and the kids knew what a presumption was. I thought you could handle it.
Yeah, I think I did.
You did. You did great.
So no, if a court wants to increase conditions, finding by clear and convincing evidence. So that's one standard of proof, right? Clear and convincing, and they have in here clear and convincing evidence is a higher standard of proof than preponderance, but lower than beyond a reasonable doubt. But then when you get into these exceptions, I'll call them, to the confinement for technical violations, they switch the burden of proof. The only circumstances when a court may impose a term of confinement for a probation revocation are new crime, or if the court finds clear and convincing evidence that the person committed a technical violation that involves a threat to public safety and they can't be safely diverted through less restrictive means. If the court finds by preponderance of the evidence, that's the different standard, that the person committed a technical violation under the following circumstances. So there's two different burdens of proof. Clear and convincing that they are a threat to society, or a preponderance of evidence that they did one of these other things. Technical violation that was sexual in nature. There we go. One of the sex offense
your
prejudices.
wheelhouse.
Yeah. Technical violation involved assaultive behavior, possession of a firearm, involved possession with intent, that they absconded, or intentionally and an unexcused failure to adhere to conditions on 3 or more separate occasions. So again, it's nitpicking, but I think that that's going to make it difficult for the courts and for probation officers and frankly defense attorneys to keep. What standard of proof are we talking about here? Is it clear and convincing, or are we going to argue over that? Is it clear and convincing? No, it's not. It's a preponderance. It could be cleaner, is my point.
Sure. And the other aspect to this is people who are currently on probation as of today's date, which is we're in March of 2024. This still affects people who are on probation now. So the law goes into effect in June, but anyone sentenced or resentenced prior to the effective date should be considered for early termination of probation. The review shall occur 1 year after the effective date. So, hey, to all my clients who are on probation right now, you're going to get reviewed in June of 2025. That's great.
Well, and I have a pretty contested probation revocation hearing coming up, and unfortunately it's going to occur in April. But I am, because I can't possibly delay it that long, but I am going to argue these as persuasive to that judge. And I did want to correct one thing. They've already thought of this shorthanded way. Termination of probation. If there are no objections to the probation status report within 30 days, the probation review conference is deemed waived, and the court enters an order noting the probation status and terminates the probation.
Well, that's what I was talking about, the objections lodged by each side.
Yeah, I'm sorry, I didn't pick up on that. So they have 30 days.
Kind of like a PSI in federal court. And I actually misspoke. It also, when it's a misdemeanor that was sentenced before the effective date in June, it's actually 2 years from the probation sentence. Mm-hmm. So it's not everybody June of 2025. Don't get excited.
You're going to start getting all kinds of calls in June.
Caroline, you said, well, it depends. Here's the lawyer answer. It depends.
I challenge anyone to find a longer acronym than CCAPPOAP.
And on that note,
well, thank you. And again, thank you to the probation officer for bringing this to our attention, because it's pretty cool stuff.
And asking for our comments. I hope that scratched an itch. And if it didn't, let us know where we can do
didn't
better.
We also want to talk about just briefly this sealing of felony records? Or is this do you want to make it a separate episode?
Let's make it a separate episode, because that feels long, like the probation tales that won't exist anymore.
Ooh, that was nice.
Thank you.
All right.
All right.
We'll sign off. Oh, don't you want to tell people that they can email us and
yes.
stuff?
I'm no good at that. Email us at subjectacross@macleary.com with any questions, concerns. We listen to you. If you can't tell by the topics we bring up, by Pete's apology in the last episode.
You're never going to let me live that down.
No, I think that was really great. I think the whole thing's great. I think our listenership is great. So email us at subjectacross@macleary.com. Signing off.
Thank you.